Ok, pues vamos a comenzar.
Hello, we are going to begin. First of all, I would like to welcome you to thank you for joining this virtual event. As you know, we are in the framework of the Week for Tax Justice and Human Rights. And this week started on Monday, May 17, and will conclude tomorrow, Friday 21st. This week is an opportunity to discuss and debate and jointly think how to promote tax measures that address the multiple crises that we are facing today in the region.
La del COVID, aunque por supuesto.
Not only COVID-1, but although it is very important.
Causada por la COVID.
But also the economic and social one caused by COVID has put on the table in a clearer way everything that's pending for us in terms of gender gaps, of climate and environment crises that we are going through in the planet, as well as the inequalities that groups historically discriminated and left behind have suffered as indigenous peoples and other groups such as Afro-descendants. Now, these gaps and these crises that are shown today to us very evidently require economic answers, urgent ones, as well as long-term strategies to leave them behind. So the goal of this week is to be able to discuss, share ideas, proposals, in order to imagine future possible scenarios where all of us can live enjoying our human rights. So, at Fundar and at the Legal Research Institute and all of the region organizations that have promoted this event, we are very glad to welcome you. Very briefly, let me mention that this week has been organized by very dear counterparts. And we've been working with them for more than a decade, promoting social justice agenda. Some of them are CIDIR, Justicia from Colombia, CELS from Argentina, also the Legal and Social Studies Center, the CSR, which is the Center for Economic and Social Rights in New York, and of course, the Network for Tax Justice in Latin America and the Caribbean, which is a network that groups 24 organizations of 14 countries. So as you can very well see, this is a regional event that's inviting voices from different civil society organizations, experts, activists, and social movements. Today, this event, this conversation, is opened by the Legal Research Institute and Fundar, which is the organization that I have the honor to lead. And, well, we have an amazing panel. We have 3 guests. And we will be discussing the number of today's session, which is taxes at the sight of everyone, tax transparency in Latin America. So as the name says, we want to reflect, we want to think together along with our guests and along with people that join us today. And we want to talk about transparency, the need to timely, disaggregated and reliably and accessibly make tax policies transparent, as well as taxes in the different states of the region. And for this, we are going to start with the presentation of Maria Emilia Mamberti. She is a consultant in terms of tax policies. Currently, she supports the work of CSR for this initiative that I already mentioned in terms of principles and guidelines of human rights in tax policy matters. But before working with CSR, she worked for ASIG in Argentina, where she led the effort of social, economic, and cultural rights. And ASIG's work is a reference in a benchmark in terms of litigation, analysis, and budgetary efforts, everything considering human rights. She has also worked with different organizations, bodies, and with different public institutions, and she leads the Faculty of Law at La Plata University. She's a lawyer, and she has different postgraduate studies and PhDs in Italy, in Argentina. So without any further ado, Maria Emilia, we've asked that to start this event, this conversation, for you to present this information about tax policies. This is a product of a huge effort that the group of organizations that I just read to you started, among others, and that consolidates human rights that, from our point of view, and experts participating should follow the policies of taxes and expenses. So, Maria Emilia, thank you very much, and please go ahead with your participation. Thank you so much, Aide. If I normally speak quickly, so this may hinder the interpreting service to English and Portuguese. So if it does, please let me know. So as Aide said, we are going to start talking about the principle linked to tax transparency on the guidelines and principles that we launched this week. So I'm going to contextualize the principles in general before. So what is the general goal that these principles aim, and why do they connect tax policy and human rights? Well, because we think that both worlds have several connection points. However, these connection points, despite being quite obvious, they are not always acknowledged. One of the hashtags or mottos of this week is that without resources, there are no rights. And this is a very somewhat way to say what has taken books and years to explain, which is it is impossible to guarantee rights without a tax policy that's aligned to guaranteeing said rights. And because obviously rights need resources to fund not only economic, social, cultural, environmental rights, as it was admitted at the beginning, but also civil and political ones. But besides this obvious relationship, there are other functionalities that tax policy that are necessary to guarantee rights. For example, we can use tax policy regulatorily to incentivize or disincentivize conduct, behaviors that affect some activities, for example, tobacco, sweetened beverages, etc. And guaranteeing rights has a lot to do with what we're going to discuss today. And it also has to do a lot with representativeness that taxes have and how tax policies could improve the rule of law and accountability. The other side of the coin has that tax policy, as any other public policy or government policy, has to be attached to human rights, because these obligations are mandatory, and the states have committed, especially in Latin America, to guarantee them at an international level. So every manifestation of state actor has to respect these principles of human rights. The way in which we propose this second relationship to the principles is that tax policy has to have, as one of the main games, is guaranteeing rights. So it is like a functional aspect of public financing and finances. Why are these principles relevant in the regional context, and why have we included them for American Latin and the Caribbean beyond being scalable at a global level? Well, first, because many of the problems that we have at the heart of the agendas of the region, it has to do with tax policy. They could be solved through tax policy, or at least mitigated through tax policy, and in general, tax policy in many countries of the region, or almost in all of the countries of the region, they renounce their potential in order to fix this. So we are talking about the most unequal society in the world, that the pandemic only increased the problems because they already had problems of corruption, environmental and climate crisis, austerity, debt, and this, of course, compromises their possibility to guarantee rights. And particularly in terms of those taxes, in many cases, as we saw in the previous panel, they end up having insufficient tax collection and regressive tax systems that need and demand more effort for those who earn the least. So this pandemic reinforced the relevance of the topic and the need to foster change and promote change, and also legitimize the new narrative in terms of the link between tax policy and human rights, including heterodox sectors that have started to talk in the context of the pandemic with this terminology or perspective that we're proposing. Some advantages that the region has, as you can see in guidelines sign principle, is that this is area that has a lot of human rights commitments that the states undertook in Latin America and the Caribbean, not really in other countries in the world, that allows creating robust analysis for acknowledging rights. So with this general framework, I would like to introduce a summary of what the principles and guidelines contain, so we can go to the specific principle of transparency and we can elaborate. First, let me clarify that the principles are the result of a participative effort, as it has been mentioned at the beginning, and that has two types of standards, principles per se, that reflect standard and regulation commitments, and guidelines that are non-regulatory, that explain how states could apply these general human rights. There are 15 principles structured in different levels, and with their perspective, guidelines, and principles brings us to the seventh principle, which has the three key and typical components of this agenda that we've discussed today, that has to do with tax transparency and participation in tax situations and accountability. This general principle doesn't mean that you won't see all the references to tax transparency. For example, everything having to do with tax collection, and I won't elaborate because Paul is going to talk about that. But it is, of course, a perspective that's cross-sectionalized throughout the document, aligned with human rights standards. And this principle considers some topics that are varied and that have to do with promoting a culture and tax education, considering the huge levels of tax evasion that exist in the region. There's also a principle talking about quality information publishing that's clear and accessible. And there's another aspect that has to do with disaggregating tax information in such a way that it allows to offer a human rights analysis related to this policy, and another principle related to generating quality indicators of human rights. We've worked with a working group of the protocol in El Salvador at an OAS level in order to discuss a little bit of these financial indicators that the states have to produce in order to prove the progressive advantages in the guarantee of economic, social, environmental, etc. rights. But this is also related to the topic that Israel is going to discuss, which has to do with the exceptions to the access of tax information and how these exceptions have to be. And now I'm going to talk a little bit more about how many times states use them in an indiscriminate way or in an excessive way. And another sub-principle that's related to participation, which is something that may be kind of stagnant compared to transparency, as I'm going to show you in a moment. Well, this principle has several guidelines linked to it, but I want to focus not really on the context of the principle that I invite you to read in the document that you can download from the page, but also to think some reactions and possible action points to implement these guidelines and principles. I mean, the principle exists. You can read it now. We have to use it. So, as some initial points, and afterwards we can discuss, and then we can conclude and start with the Q&A session. This principle has some strategic advantages. The first is transparency. Let's say that it appeals to a very broad public. So if it is related to tax transparency, that it has an ideological advantage. There are many fields where we can agree for the concrete application of rights and standards that we have synthesized in the document. Another advantage is that the pandemic caused scandals of different nature that happened at different places of the region. And the other advantage is that facing the response, saying that there are no resources for this right, for example, the right to public information and the presentation of a cheap one. And of course, this is a false argument that cannot really be considered. And also in budget matters, many courthouse this, including the Inter-American Court, says that it has a reinforced view, everything having to do with public resources. So there is like a very strategic standards that we can consider. Some general actions show that we have to take into account, as well as in other topics, that there is a huge diversity in the status of the countries in the region. As an example, the graphic results of the last index of open budget, and I think that someone already mentioned it from the panel, or they will, but I don't want to really make any mistakes here. So the map shows how the status is not the same in every country of the region, and we need to contextualize the general situation to the specific situation. And in terms of index and surveys, even if the transparency package accountability can come hand in hand, in general, there has been more progress in terms of transparency, but we are still a little bit behind in terms of participation. And what can we say about accountability? Some topics considering control organizations, impact assessment tools are in zeros, and this is a problem for civil society. Being able to go inside the world of tax tools, it is still a technical aspect that's quite never ending. Also, besides diversity at a regional level, in countries, federal ones, for example, in Mexico, Argentina, and Brazil, there's a lot of diversity at a local level. So the principles aim to discuss producing information at a local level. But here we have challenges to even generate capacities at a local level. So advocacy, of course, has to do with working together with these local governments in order to promote transparency, tax transparency. In terms of transparency, there are some modern information access laws, and something important to mention that we have to focus not only on publication of this, but also the quality of it. Sometimes there are countries that do not want to share it, but there are others that do not really produce it even. So that's why they don't share it. And the processes that Colombia is going through and Chile at the time shows that tax policy needs to be built according to Principle 7 so that it can be at least legitimate. And before concluding, I want to add as an example things that I consider to be significant and that have to encourage us in this agenda and some of the pending challenges to think together towards the future. Significant processes. We have litigations by a foundation such as Fundar or ASIR that have reached very good regulations in terms of tax transparency in aspects such as low tax benefits. Other significant progress is that there are modern laws in terms of information access, which is the general framework that should be applied in the tax information that shouldn't be excluded in this legislation. There are progress in participative budgets or in budgeting by specific programs in terms of gender. There is also progress in production and publication of budgetary information more than tax collection, accessible, and it's updated in many cases. Argentina has had a lot of progress, for example, during the last couple of years in this field. And the same thing with open data situation that, of course, it's included in the principles and guidelines. In some areas tangentially related to tax policy, but related to public spending, for example, public purchase. And now challenges, which is what I would like to discuss, or for you to leave us ideas in the comment in the document that has been shared through the chat. So how can these principles fight these challenges, face them? The first one that I identified has to do with an exaggerated narrative of tax privacy for two reasons. First, because this is applied selectively. It appears to protect only certain taxpayers and not others. In Argentina, for example, the Supreme Court of Justice considered that the information linked to social security was not sensitive data, hence it should be provided to the NGO that litigated this case. And this is what evidenced the fact that ownership information shouldn't be excluded to the access to information. I mean, if you Google information on what in Argentina we call mono taxpayer, which is a webpage for small taxpayers, you could see what type of activities they do, and you can also ask for the invoicing services and activities of that company. However, it's quite quick in answering that the referred information for larger taxpayers, then it is protected by tax secrecy. And this is, of course, another problem that Israel is going to detail because it is quite exaggerated. This does not respect the rules of exceptionality that I was telling before, and that we mentioned in the principles that are applied in terms of access to information. Another challenge is to move forward with local governments publishing reliable indicators. And for this, there is a generalized problem, which is a lack of coordination between government entities and those who have the information, those who produce it. In my experience, at least in the Argentinian government, talking to the Protocol of San Salvador members, it is hard to know if there is enough coordination between government agencies so that the information produced is of quality. Those who have the obligation to publish it is not really the same one that has the information needed, the basic one, for a quality indicator. So a challenge that's universal, let's say, is achieving the implementation of fundar regulations or progressive ones, for example, access to information. And we have had some progress in acknowledgement, which is great, but we've had good rulings on how we are able to bring this to action. How can we bring accountability to those regulations that are not met? And the last challenge would be connecting transparency agenda with rights. So it is not an abstract institutional aspect. There are many more, but I don't have any more time, but this is all on my part. Thank you very much. Thank you so much, Maria Emilia. I think that you have given us a broad overview, first of all, about what's the purpose of the principles of human rights in tax policy. And I'd like to readdress something that you said. At the end of the day, the elaboration and the construction of this series of principles of human rights in tax policy has been a process, as you very well said, a broad process in terms of consultation, participation, even in time. We've been for almost 3 years preparing this document, and we believe that it is a very robust document of standards with which the states of the region should adhere to, which they should adhere to. But the challenge here is for them to be used. What we don't really want, organizations behind this work is for them to remain as just faraway principles, far from civil society, far from gender agendas, environmental agendas. I mean, what we truly want is to find a way to use them so that they can serve fights and agendas. And this is because there is on the chat a link to a document where we would like for you to share your ideas about how to make these principles useful, how to bring them where we should bring them, as well as materials, products, so that we can start compiling them so we can share them later on. I also forgot to say at the beginning, but I tell you now, that there is simultaneous interpreting in English and in Portuguese. So in order to be able to hear it, we ask you to go to the web page of the Tax Justice Week, and there's where you will be able to hear this conversation not only in Spanish, but also in English and in Portuguese. And well, as I said, you are offered an overview, but I think that talking about transparency, yes, we have moved forward more in transparency than in accountability and than in citizen participation. And the IVP index shows it very clearly. But we also saw that in the transparency agenda, there are still obstacles, despite the institutional framework that the region already has, and that's quite solid in many cases. For example, in the case of Mexico, there are still obstacles to prevent access to information, which is fundamental for accountability, for example, tax secrecy. So we agree that there is an exaggerated use, a selective use of this tool not to provide accountability and not to provide information that we believe to be socially useful and very important. So analyzing these obstacles that still persist to know very useful and important information, we carried out in the framework of these principles a series of complementary documents that elaborate on obstacles and challenges related to, in this case, tax transparency. So Israel Santos prepared a document that elaborates on tax secrecy and access to information and transparency, which is also available in the webpage. And of course, he's going to tell us a little bit about the findings of the document that you can see on the webpage. And before passing the floor to you, Israel, let me introduce you. You are a doctor in law. You have a European mention by the Madrid's Complutense University, and he has specialized in tax law, especially in international tax matters, and he is a counterpart that we value and we acknowledge a lot at Fundar. So Israel, please go ahead. Thank you so much, my dear Aite. First of all, I'd like to congratulate you for this regional effort. These meetings are necessary, not only publishing this document that, as you very well say, has taken 3 years of your time, but also to disseminate it. So this type of events, of meetings, contributes to this. So I would like to congratulate Fundar, you, Aite, Ivan, all of your team for the invitation to join you this day. Yes, as you very well said, I'm going to share a presentation. Give me a moment, please. You see it there, right? I'm going to talk a little bit about the goals and the findings of this document on tax secrecy. So basically, the goals were mapping a regional mapping focused on 6 countries: Argentina, Brazil, Colombia, Mexico, 4 countries, or in order to study the regulation of tax secrecy. In some other countries, they know it as tax reserve, or in general, the basic regulation would be absolute confidentiality that has to be demanded from public officials that work in tax related bureaus. And we need to find what's its link from a perspective of human rights and how this tax secrecy has hindered process to information to transparency in the region. And for this, the goal was to consider forensics in cases how courthouses and justice bodies and institutions in general have helped break down that stone, that big obstacle that's called tax secrecy. Of course, it has its good parts. It has a reason to exist. However, tax secrecy could not be an obstacle to prevent access and exercise to other rights, such as access to information, transparency, etc. Why is transparency important? We have to ask this, you know? And Maria Amelia already said it, and it has been said here. What are the benefits for the state? Not only transparenting tax information, but in general, all of the public state activity should be transparent, open, of open access, and friendly and easy to be understood from by anyone. So this transparency, of course, helps, first of all, increase the levels of tax compliance. Why? Because it generates certainty, generates legal certainty. If we have a transparent institution, I know as a contributor what I can expect. So this reduces this discretionality management, and the authorities then can adhere and respect even equality criteria when addressing tax aspects. It happened a lot, for example, in the Mexican case, the tax consultations. One presented a consultation, and I couldn't know why management would say that my expense was deductible, but not to ID. I didn't know why Paolo was told that yes, he had the right to apply a certain tax stimulus, but Maria Emilia no. So this, of course, generates inequalities, a perception of mistrust. If tax collection is transparent, then this will incentivize and encourage the taxpayer. So it truly increases tax collection because the taxpayer will be more motivated to the voluntary, spontaneous payment of tax obligations. And in this sense, as you can see in the last bullet, transparency is also an instrument for this fight against fraud, tax evasion, and we can even extrapolate this to a global level. As you know, currently efforts existing at an international level, G20, European Union, OECD, Inclusive Framework, UN, in order to achieve transparency so that we all agree that we have to pay according as it should be based on this tax payment capacity, tax payment equality, etc. However, there is a tension between that tax secrecy and access to information, and it is not for free. We have to remember, and I am not really finding the black thread here. We know that legal certainty that all Latin American Caribbean countries have is a reception of that tradition of the Roman law, the continental Roman law, which is quite inspired in Spanish tradition. Now, all of the norms and standards in general on tax law helps us explain why our tax laws, why our tax ordinances are just as strict, because from their conception in that continental right, as we say, inspiration of Roman law, tax standards have always been considered as an exception standard, as special rules that are prepared apart. So you interpret it differently. strict interpretation. I'm sure you've already heard here that tax standards shouldn't be interpreted, because if you do, then you risk benefiting the taxpayer or affecting tax collection. So these are exceptional, overwhelming measures that have to be governed by other parameters. And of course, we feel this with economistic points of view. Let's remember that everyone studying these tax aspects were economists, not lawyers. We have David Ricardo, John Stuart Mill, books, Adam Smith books, etc., etc. And when law receives this tax matter, then it's hard providing it with legal content. The Italians were the first ones discussing how we can find subtracts that's stripped from economic notions, so we can give it some economic touch. But as I said, this is basically done by Italy, is readdressed by Spain, and Spain oriented by the German doctrine. And we, Ibero-American and Mexican, Spanish-speaking countries, Mexico, Colombia, they adhere to it strictly. You can read all of the Ibero-American countries and you see how these considerations start getting repeated. And among these, we had tax secrecy. So it gave them like a duty from the public servant. So let's think that we're talking about 100 years back. The first code was of 1938, so it's already 90 years, something like that. And tax secrecy, as I said, is indisputable because it is what the tax policy should be, to keep that secrecy. That's how it was regulated since 1938, and we can also go over the codes. So what does this make? Well, in society's evolution, when we start talking about right to personal data protection, but also the right of access to public government information, then we start finding a collision between these two, between a right that's completely absolute, a duty, but what happens when I have the right to ask for public information? And of course, reluctance is found in administrations themselves. I mean, it's not that I am adhering to the right of absolute secrecy. And of course, this collision is the one that has made our rules about access to public information, or on the other, not the other way around, our tax standards do not address progress that we've had in terms of access to public information. So what are the exceptions to tax secrecy? This is more recent. It has been from 20 to 15 years ago. And of course, tax secrecy does not happen in every case. So if we find a taxpayer that do not meet the responsibilities, one that has been already sentenced, but because of a tax felony, money laundering, among other money deviation, and we cannot find them in their fiscal address. There are taxpayers that have received condemnations, credit cancellations, a story that Fondar already knows a lot about it, and I am sure we'll talk about that too. When there are these type of situations, then we start seeing that ordinances start acknowledging a relaxing of the tax secrecy. So all of this is new, is on the law. So what has the judicial branch said? Well, here it has been the interpretative job of judges, of courthouses. They have been the ones to have been able to eliminate or try to or surpass this tax secrecy. I'm going to share some examples. So tax secrecy cannot be the information that's reserved just because it is, you know? So when the authorities see that there is a tax reduction, they have to justify it and not only say, well, it is not reserved, but the information is inexistent. Sometimes they protect in this inexistence of information. They do not really act pro-public institutions in order to share that information. So when management says this, they have to justify it. So this reserve could be extended, as you can see on the second bullet, by the legislative branch also. This is the case of Brazil, provided there are always evidences of a possible crime or illegal action being committed. And the same thing happens with money laundering operations. So, when we find that there is a gap between a possible non-compliance and fraud-related activity, then tax secrecy does not protect that data protection on behalf of taxpayers. And in the last bullet, as you can see here, in Mexico, we also have this. What is the relationship between the right to audience? When this access to public information does not mediate, providing formalities or audience notice to people whose data are going to be revealed when there is a public interest that has been surpassed. So when information is of public interest, the right of audience does not mediate, because in this case it was won by Fondar some years ago. So what are the arguments that we have? Well, we shouldn't really satanize tax secrecy. Of course, there is a reason why our data has to be protected. This, of course, in terms of public interest, even national security, homeland, even the absolute respect to our information, my name, my address, but also ones that are related to tax matters. How much I pay, how much is deducted. Yes, of course, there is a protection. But that protection is one thing, and the other would be the perspective, as it has been mentioned before, the interpreting of this usage of tax services from a point of view of human rights. So then here we find that the principle of maximum information advertising is the one that should be our starting point. So we have changed from saying tax policies panacea. Now we have a principle of maximum advertising. So the rule is this: information is public. We are going to see if there are exemptions now. But in principle, information should be public, transparent, accessible to anyone that requests it. And yes, if we find a collision, as we said, and this, of course, basically brings us to Robert Galexi's theory, this test of proportionality and reasonability judgment, as it's known in other places, through these three phases: and proportionality, adequability, and suitability, in order to know if restricting or forbidding the access to information overcomes or not this reasonability test. And in this sense, we need to know if the principle of maximum advertising should rule or not, because as we've said, that should be the rule. Some findings of this document. Well, first of all, when this document was being drafted, one of the goals was looking for good practices in the region. I wasn't able to document per se good practices, good administrative practices for access to information. I think that tax offices are still a little bit reluctant. It is still hard for them to open up to this transparency. Other finding is the role of judges, which has been fundamental. And judges not because they are going to fix things for free. The civil society and organizations have been the one, such as Fundar, for example, that through this strategic litigation have been able for the judicial branch to open their eyes.
En estos casos,
pues also transparency organizations have helped to defeat these obstacles that are presented by access to information. We already talked about proportionality test. And last but not least, I would reiterate that we need more transparency, more information, because this is going to improve tax morale and tax habits that in the region, with some exceptions, it is quite low, and the exception would be Chile here. So as I said in this part of the good practices, what was documented was some of the things that add up and that deserve being mentioned. First of all, the need for administrations to periodically publish management reports. Many do this, but they have to be simple. They have to be drafted in a clear way. They shouldn't be ambiguous, full of jargon, etc. And the publication of all of the tax treatments, for example, condoning cancellations, exceptions, certain stimuli that are offered not really by law but by presidential decree. This transparency, well, we also need to have access to that data. And when these data are published, then there also should be a micro data published that are anonymous. Maremila already said it. Those who are poor, quote unquote, those who get a scholarship, the indigenous boy that gets a scholarship, we transparent everything. We know where he lives, what he eats, that he suffers. But the huge and big taxpayers, then we protect them. We don't know how they are, what's their name, what they do, or their economic operations. So here there should be a data separation, even by type of taxpayer and the economic activity that they do, the state they belong to, even the municipality, neighborhood, region where they do their activities. If they are people or companies, if these people gender, maybe not their full name, but data that allows us to better know how the taxpayer database is formed in some countries. Also, we have the use of technologies of information and communication. As you very well know, and this has been implemented by regions countries, Chile, Argentina, Peru, Brazil, that of course, we have Paul here in Mexico, disruptive ones. Machine learning, data analytics, blockchain, Internet of Things. We still need to use these technologies, but of course, this use has to be transparent. And let me share something very quickly. I am working on a research on how is tax administration, the IRS in Mexico, uses artificial intelligence, because it is something that the IRS reported during the last tax and management report for the last quarter of 2020. And when they ask for information to say, okay, and how do you use AI tools, and they said that there's no information, they don't know, where we're always bragging in international fora. There are reports of the IATB that Mexico is a country that's at the tip of the spear that uses disruptive technologies, and in the region, electronic billing and invoicing, we're pioneer. However, we don't know very well how to use it. So here we also start seeing that there are other challenges. Transparency, algorithmic transparency, knowing how those AI systems work that tax administrations use in order to prevent non-compliance risk, fight against fraud. Today, there could be data on us being shared, but we don't even know how those algorithms work. There should also be a cognitive principle. I'm sorry if I took a lot of your time. I don't want to overwhelm you. And it is also important that at a regional level, IDE, to keep on doing these efforts. Now we have a very convulsed region. You are seeing what's going on in Peru with elections to come that are just fatal, the extreme right and the extreme left. You see what's going on in Colombia. And as of a tax reform, this convulsion is happening, this social convulsion. And what's going on in Chile, this calling to a new constituent to repropose a constitution that's oriented to what tax policy, left or right type of tax policy. And of course, I won't even talk about Mexico. So the region in general right now is in crisis, and it is important to use tax instruments and tax policies from a human right perspective so that, yes, tax systems are efficient and they can be used for what they are aimed to. Thank you very much. Thank you, Israel. I would like to invite people to download the document and to go over it in detail, because I think that you, in detail, explain tools such as tax secrecy. I think you said it impeccably. Legal instruments such as tax secrecy that comes before standards and regulations in terms of transparency, access to information, accountability. So these are tools that state on our laws, on our constitutions, or our institutional and standard and regulatory frameworks, but not all of the countries and not all of the legislation have standardized it with relevant principles of human rights, for example, the maximum advertising right. So I think that this is a first agenda aspect for organized civil society. How can we knock down those instruments that, as you very well say, it is not really about demonizing them. That has never been the intention. However, and I think that you've said it quite clearly, today secrecy should be the exception. And that's how the maximum advertising policy sets it. And states, governments, and authorities have a responsibility, which is doing a case-by-case analysis in order to decide if this maximum advertising applies or not. That's why generalized secrets would be completely unconstitutional, for example, in the case of Mexico, and contrary to international standards. So I think that the first work line from civil society will be advocacy in regulatory frameworks, but then it happens in Latin America and Mexico, where specialists we have tip of the spear laws and rights, and when implementing them or putting them into practice, we need to go and fight at the courthouse. That's the case of the litigation that we have in terms of cancellations and exemptions. Despite the Constitution was reformed, despite transparency obligations were published, and the information related to condonation and cancellations, the authorities have a vision of heritage of information, and we should say it. In Latin America, we have captured states. There is a capture of the states because of economic and political interests that fight hard, and that information that affects their interest and that's revealed, well, causes, of course, a fight. So fight is in regulatory frameworks, but also in administrative practices. And I think that in this case, it is about strategic litigation. So information is not going to be open. It won't be open if we don't fight for it from organizations, from movements. And hopefully these principles and these documents can be used to elaborate on the argument on why this information is useful at a public and social level. It would appear that this is a technical matter or legal argument matter, when in reality we know that this is a political matter, that there are interests, hidden interests that are being affected, and that's why they fight for tax secrecy. So if we don't understand that this is a political dispute, then we are not considering all of the information. We're falling short. So it's important to tell the story the way you have told it, and very clear arguments about why is it important for tax equality and to even increase the tax capacity so that states trust that they're being treated equally. So I would like to thank you very much for your invitation, for your participation. I want to invite people to go over the document. And now I would like to pass the floor to our third guest, our third panel member. He is Paolo de Rencio. Paolo is a senior researcher of the International Budget Partnership. And as I'm sure that many of you joining us know, that it is an international initiative that has been working for decades pro tax and budget transparency. And his research agenda includes transparency, accountability, equality, justice, taxes, tax collection. He's a specialist in these matters that has brought us here today. He's also been consultant for different international offices, such as the World Bank, OECD, European Commission, etc. He has a PhD in international relations by Oxford University, a master's in development studies in the London School of Economics. So without any further ado, Pablo, please tell us a little bit more tax expenses. I wanna ask you to please explain this in detail, because tax secrecy, I believe, it's easier to understand. It has become a problem a little bit more, but the term of tax expenses, it would be good by saying what they are, why should we consider them, I mean, for starters. So I would like to pass the floor to Paolo. Thank you so much, Aide. And let me see if I'm able to do something that helps everyone understand tax expenses. Thank you so much for the invitation. And congratulations, all of the organizations that are part of public policies and human rights, and for this week's events that are being very interesting. And I think that many panelists in many of the events have already talked about the relationship between tax systems and human rights. Tax systems affect inequality and discrimination levels existing in our society. They generate resources to fund human rights, and they should be transparent, and they should have the right level of accountability. So tax transparency is a fundamental element to guarantee that tax systems positively contribute to human rights. My contribution is a specific aspect of tax transparency, and it is a topic that we have been working with a group of 10 organizations in Latin America, Fundar among them, that works on tax justice, and also includes some of the organizations that are part of the initiative of tax policy and human rights. And I am not going to focus on taxes that companies and citizens pay, but on those that do not pay and that governments allow them not to pay, giving up important resources for the inclusive development and promoting human rights. And I'm talking about those who are called tax expenses or fiscal expenses that include exemptions, deductions, other type of tax reduction that governments use for several public policy aspects, for example, promote investment, influencing consumption decisions, affect distribution of income, among others.
Un instrumento legittimo de política fiscal.
Despite being a tax policy legitimate aspect that can be used in a justified way, for example, promoting investment or redistributing income, experience has shown that very frequently tax expenses, as you very well said, Aite, captured by particular interests and very powerful interests. And this is why they end up distorting the tax system and acting against their declared goals, providing tax privileges to players that do not need them. Here we have Fundar's work, which has been very important once again, and in this way it aggravates inequality in tax systems. Another problem that exists with tax expenses is that they come from a deep lack of transparency and a very weak accountability. Many of the countries, not only in Latin America, but in tax expenses, is not published, or it is published very limitedly, and the decision-making processes related to tax payment are quite opaque, and this is why they are prone to abuse. Why is this important? Well, because we need to do something about this. I mean, good part of the country's tax collection could represent up to 3 or 6% of the GDP, or up to 20% of government income. So it is an amount of resource that's very important, and that's why it is so important to promote transparency and accountability in terms of these tax aspects. And in this area of civil society plays a very important role, addressing governments for them to publish more information and to use this information to produce analysis on the impact of tax expenses, denouncing the ones that are inefficient and useless, and there are many of these, and asking reforms in tax expense. Talking about transparency, with this group of 10 organizations that I already mentioned, we've started carrying out some activities in advocacy that has shown some of the key problems with tax expenses in the region. So what we did was examining reports of tax expenses of 15 countries in the region, and we verified what type of information they included. So comparing the information that exists with a list of criteria that we have extracted from international existing standards, but also comparing them with the need for citizens' information as well as civil society organizations that ask for accountability and more transparency in this matter. So the main result was that even most of the governments in the region and in Latin America, this is done way more than in other regions of the world. There are annual reports on tax expense, but the main point is that information that we have tends to be of accounting nature, and it is not enough to allow the right accountability. So I'm going to share here on my screen so I can show you a table included in our publication about this topic that has some of the main findings. Let me see if we can see it here. So, what you can see here very clearly, we have 15 countries. We have included Canada also because it is a country that has some of the reports on tax expenses that's the most complete in the world. And we have several criteria, several type of informations on tax expenses that we have included in our analysis. And what can we see here very clearly? That accounting type of information on the type of tax expense over the amount of income that were exempted on the methodology used to calculate those tax exemptions. This type of general information is almost always present, but other type of information is the type that allows accountability. So what are the goals of these taxes? What are the performance indicators where we can actually measure these to see if they're effective or not? Who are the beneficiaries benefiting from these tax expenses? What is the distributive impact? And what is the methodology that are the results of assessments that have been done? I mean, this type of information is mostly absent. So this is why it's so hard to know if tax expenses are of impact, who benefits from them, etc., etc. So here, tax secrecy is also very important when we attempt to know who are the main beneficiaries of tax expenses. And once again, here we see the main beneficiaries, the most powerful ones, the ones that hide behind the shield of tax secrecy, so to speak. So after the pandemic of COVID-19 exploded, we were using this analysis as a basis. There was a call for the region to revisit this tax expense as a way to collect additional money to fund emergency expenses, but also economic activities to guarantee basic rights during this complicated phase and this hard phase of tax activities for economies and societies too. And it is a way to reduce the negative impact that tax can have on a population that has grown in this period, in these hard and difficult periods. And many other institutions have also stressed on the need to reject the tax policies, tax expenses policies, as part of government answers to leave the crisis. Unfortunately, the lack of transparency is still causing very important obstacles in this path. Hence, and last but not least, I think that promoting human rights and promoting transparency go hand in hand, not only because access to information is a right in itself, but because without the right transparency, fighting for other rights is going to be way harder. Thank you very much. Paolo, thank you so much for your presentation. At the end of the day, tax expenses or tax reductions are also something that's important to check, to go over, to understand, and for us to be aware of, because as you were saying, with this impressive data of this 20%, I was not able to hear very well if that data was meant for a country specific or a region in general. It is an average in Latin America. This is the amount varies from 10 to 20% of income. So let's say that states stop collecting between 10 to 20% of their budget due to tax exemptions or tax reductions. Well, I think that we will have this as a takeaway because it is very specific of the resources that states do not receive, especially in a pandemic context and crisis context, such as the ones we're going through. Well, the argument is that there are not enough resources in order to address the right to health, as well as many other rights that have seen violated before the pandemic, of course, but now even more than ever, which generates a lot of concern. So this is one of the takeaways that's very important, and it's quite clear what is the importance. As you very well mentioned, and as Israel very well mentioned, it is quite complex talking about tax policy. It is complex to talk about the need to increase taxes. However, there is work in terms of advocacy. There's like a work close season by academia, because there is a lot of resources that the state is not perceiving, and that we should go over them so that we could foster and promote those taxes to be paid and to be used adequately in order to reduce the impacts of the pandemic. So yes, I really want to thank you, Paolo, because you have given us a very concrete image, the table related to what is the information available and which one isn't in Latin America. So half of the table is red. So I think that this reinforces the fact that there is a need, the number one need to have a principle, which is a principle related to transparency and accountability and citizen participation in tax policies. It also clarifies the need to keep on fighting tax secrecy from different strategies, from different sectors and actions, and also to keep on working broadly so that we can share information on tax expenses, which would be fundamental resources for crisis times, such as the ones we're going through. I want to thank you, Maria Emilia, Israel Santos, San Paolo, Rencio, for your participation. Now, Carol Mota is going to share the illustration of this conversation. Now I'm going to ask her to share her work. We truly love the fact that we can graphically show what we've discussed during events and conversations such as this one, because she is a master, because she collects real-time the main ideas of a discussion that's quite complex, technical, but in only one picture. And she can share key thoughts. So we believe that this is important information and material to share. So this is going to be the graphic a summary of Principle 7, tax transparency, where on one hand, it puts us on the importance of having transparency in our tax system, as many of you have already shared. It also shows, as Maria Emilia already said, the hashtag that we've been using during this week: without resources, there are no rights. And this would appear to be quite obvious and basic for our community, but it is not always so for everyone. And how, at the end of the day, there is a dispute, there is a political dispute related to tax policy, because deciding who pays and who doesn't pay and who will be affected and who aren't affected, this transcends technical arguments. It transcends regulatory arguments, and hence the importance to mobilize and to build collective agendas in this matter. So I want to thank you, Carol, and I truly want to acknowledge your work because it is always great. You will also find all of these illustrations in the page of the week. We are being asked Paolo's and everyone else's emails. We are going to share them on the chat. And last but not least, remind you that tomorrow is the last day of the week for tax, justice, and human rights. We will start at 9 a.m. Mexico City with a panel that's called Principles and Their Contribution in Global Fight for Tax Justice, which is going to discuss the usefulness of these principles that we have carried out. So thank you so much for sharing the screen. If you want, we can take the illustration. Just to once again thank our three panelists and everyone that came to this virtual event, and invite you to accompany us tomorrow in the next conversations. And thank you so much for being with us today. Have a great afternoon. Goodbye.
Política fiscal y los derechos humanos. Los derechos humanos son los derechos que toda persona tiene por existir. La política fiscal es la forma en la que el gobierno obtiene los recursos para financiarse y cómo los gasta después. Esta política puede promover o generar retrocesos en la garantía de los derechos humanos. En América Latina, la región más desigual en el mundo, durante la pandemia por COVID-19, 73 multimillonarios aumentaron su fortuna en $42,000 millones, mientras se estima que 52 millones de personas ya han entrado en la pobreza. Esto demuestra que los países de América Latina no están cumpliendo con los acuerdos internacionales de derechos humanos que suscribieron. Si estos acuerdos internacionales fueran cumplidos, la política fiscal estaría al servicio de las personas y sus derechos en vez de restringirlos, que es lo que sucede hoy en la región. Con eso en mente, 7 organizaciones en América Latina se propusieron analizar estos acuerdos internacionales y aclarar cuáles son las implicaciones en derechos en materia de política fiscal. Así, surgen los 15 principios de derechos humanos en la política fiscal, que al ser aplicados por los gobiernos asegurarían que las políticas fiscales estén al servicio de los derechos. Algunas de las ideas en el documento aclaran que el Estado necesita recaudar impuestos de manera justa, de forma que los más ricos contribuyan más. Que las mujeres, las personas afrodescendientes, los pueblos indígenas y las comunidades que han sufrido discriminaciones deben tener prioridad en las decisiones del gasto. Y que la política fiscal debe ser transparente, participativa y sujeta a la rendición de cuentas. Si quieres saber más, visita nuestro sitio web